Jacob Zuma and French arms company Thales is back in the Pietermaritzburg High Court today. Judge Nkosinathi Chili has set it down as a holding date while he considers Thales' applications to be acquitted on all charges due to the death of key witnesses in their case. Zuma's legal team has brought a similar application, saying their right to cross-examine witnesses will also be affected. Zuma and Thales are facing charges of corruption, fraud, racketeering and money laundering stemming from South Africa's multi-billion rand arms deal in 1999. We're joined on the line by legal analyst Mpumelelo Zikalala to talk further on this. Mpumelelo, thank you for joining us and welcome to Africa Rise and Shine on this Tuesday.
Good morning to you and also good morning to our viewers.
All right, Zuma is back in court this morning. What can we expect?
Basically, a holding date to test where the parties are in the different or respective applications that they are there. Remember, Mr. Zuma himself has made a number of appeals to the SCA and also to the Constitutional Court. And remember, there's also that outstanding ruling that would need to be delivered by Judge Chili of detailing. Do you give out an order that says the trial cannot move forward, or do you say the application is dismissed? So on today, then they'll be able to know and check how far are they in terms of their respective applications that they are there. And when you come back on the next day or the next occasion, are we able to start the trial, or is it another holding date to determine whether the parties are ready to proceed with the matter?
What is the likelihood of Thales' application being granted with the explanation that two key witnesses have since died? And do you think they can have a fair trial if the two most important defense witnesses have died?
Well, it would depend, but the most important question would be what type of evidence was going to be laid against you. Do you even know what the state is going to state? Have you experienced those difficulties? So that's the one thing in which maybe the court would like to err on the side of caution on, in terms of saying, well, I'm not going to give you the benefit of the doubt now because I haven't even heard whether those witnesses would have been credible witnesses, number one. Number two, would have they assisted the court in coming to a conclusion? So let's rather start the trial. Let me hear what the state is going to state. And if there are any difficulties that you are facing, it's only then you make your application or highlight to the court and say to the court, had it been that our witnesses were alive, they would have disputed whatever which is being stated here. So when you make your ruling at the end of the day, we want to rule this particular conduct as conduct in which would fall on the unfairness of the whole process. And the second part is this one. You can't wait up until the last minute before you make the application for unreasonable delay. It has to be done as soon as the delay has occurred. So Thales has stayed all this while, knowing very well that the matter will still be able to continue and did not complain, and only at this minute only raises this particular point. Also something that the court may also look at and say, I'd rather err on the side of caution. I want to hear the evidence, and after hearing that evidence, I'll be able to make a determination. But to rule that the evidence is not there from the instance is not a gamble that I'm prepared to take.
What would form alternatives now if you were the legal counsel for Thales in terms of the ability to cross-examine these two key witnesses that would be of equal value?
Well, it would be to provide documentary evidence that would have been there, which would be able to corroborate whatever is being stated. That would mean let's go back to the pre-trial conference again. Let's check whether any evidence can then be sourced. Or if there are any additional things in which you'd like to source, let's start there and see. Can you be able to provide that evidence? Is it going to assist me in the manner in which I want to render my trial? Other than that, it's a wait and see type of game in which you would have to wait up until the process is done, up until the witnesses actually come into the witness box, and then you'll be able to deal with it in that particular sense. But to simply want to rule it out from the instance is something which is impossible, and I don't think the judge or even the court would accede to that.
In April, Zuma's camp was awaiting Judge Chili's judgment in the former president's application for leave to appeal the ruling dismissing his request for Advocate Billy Downer's recusal. In your view, would the advocate's recusal contribute to a fair trial for Zuma?
No, not necessarily. Remember, a person who's at court is free to decide the strategies that they want to engage in. So if they want to have Advocate Billy Downer, then so be it. If there are any instances of unfairness that would have been raised, there's a very leading case of S versus Porritt that says you're not going to be able to win this particular from the first instance. But what you have to do is that during the trial, show instances in which the lines have been crossed, and show instances in which the crossing of that line is going to lead you to having an unfair trial. So the court is not saying to you, I'm simply shutting the door so that you're not able to raise evidence, but it says, for me to be able to decide this matter accurately, show me those finer details in which the law has been transgressed, and then maybe I can find in your favor, if then I can see that an unfair trial has taken place. But to simply assume when there's no evidence that has been led, there's no indication of facts that can be adduced by the court to say that an unfair trial is going to be made, then the court will not allow it. So the chances of maybe even on appeal and even going up to the Constitutional Court, Zuma's applications being dismissed are very high.
The case has dragged for years. Mpumelelo, are there any signs to an end?
To be honest with you, I don't think so. When we first started with this matter, I'd said 5 years. And then even last year again, I said maybe 5 years before we even see the first witness going to the witness box. Because after this traversing to the Constitutional Court and coming back, Mr. Zuma still has other avenues that he can be able to raise. And if the matter is then continues despite whatever challenges are there, then it would mean a travesty in the manner in which we do things in our courts. So we may see maybe 5 years or maybe 3 years from now, the first witness going to the witness box. But that is if there are no any other pleas which are going to be raised by the former president.
All right. Well, let's leave it there. Thank you so much again for your time, Mpumelelo.
Thank you very much for hosting me.
Great. Mpumelelo Zikalala is a legal analyst talking to us about the corruption case against former President Jacob Zuma and French arms company Thales. They are expected back in the Pietermaritzburg High Court today.